here. Hello, everyone.
Hello.
Thank you so much to the Humanist community of Silicon Valley for inviting me to speak here today, and thank you all for joining me in hearing about this wonderful national movement that's been taking place for going on 10 years now. So a little bit about myself. You already heard a little bit about me, but my name is Keyan Bliss. I'm the Grassroots Volunteer Coordinator for the Move to Men Coalition. And nearly 6 years ago, this past July, or actually over 6 years ago this past July, I first learned about this movement to amend the Constitution, just working as an hourly wage worker, basically. I was a political science graduate looking for a purpose-driven career that actually paid more than just experience while making my ends meet to pay off my student loans. And as far back as my high school education, I had noticed that there was a profound lack of free choice in the land of opportunity that routinely touts itself as the greatest, freest country on earth, especially being a person of color living within predominantly white communities. And when I first learned about Move to Mend, what really fascinated me about them was the fact that they were the only organization that was committed to systemic transformation that particularly centralized the dismantling of oppressions and building a multi-ethnic, intergenerational, cross-class movement to actually change the foundation, like the fundamental law of the land. And that's what I'm here to talk with you all about today. A little bit about what Move to Mend is. Move to Mend is a nonpartisan national grassroots coalition of more than 460,000 people and over 500 organizations committed to social, political, and economic justice and equity at all levels, ending corporate rule, and creating a genuinely democratic society that is accountable to all people, regardless of race, gender, or class, not just corporate interest or property rights. Together, our coalition is calling for an amendment to the U.S. Constitution, which will unequivocally state that corporations are not people with the same inalienable constitutional rights as human beings, and that money is property and not a form of protected political speech, so that we can actually regulate it within our political process. And our strategy to getting to this, of course, is to build that multi-ethnic, intergenerational, cross-class movement that is powerful enough to change the supreme law of the land, our founding document of the Constitution. And it's also to do this, we seek to provoke discussion and organizing around how we transform our current system, which is heavily weighted in favor of wealthy corporate interests, into a genuine democracy that is rooted in justice and equity for all human beings. So, this movement got started 10 years ago, this year actually, this fall, coming in September, and it came from a decision most of you are probably all aware of, Citizens United versus Federal Election Commission. And this decision was the first case that recognized that corporations as a legal entity have inalienable free speech rights under the First Amendment. And this effectively opened the floodgates so that corporations and their nonprofit subsidiaries could explode the creation of super PACs and basically spend unlimited amounts of money to influence our political discourse. And while many organizations have risen to overturn Citizens United and focus exclusively on just getting money out of politics, for very good reason, the root of the problem actually goes much deeper than just Citizens United, and it goes further back than 2010. And we know this when we recall recent history where we can see that the amount of money to influence our electoral process has been excessive long before Citizens United. In fact, the difference between the 1998 elections and the elections in 2010, right after Citizens United, was actually just $3 billion. Actually, I'm sorry, $2 billion. And let's be real about that for a moment. Any election that costs more than $1 billion is excessive and obscene. Full stop. Furthermore, long before Citizens United, our elected officials have long maintained their staying power thanks to wealthy benefactors who have been giving and funding their campaigns, where incumbents at all levels of government, local, state, or federal, have a 98% success rate when it comes to re-election, and oftentimes running unopposed more than half the time. And furthermore, outside campaign contributors to our elected representatives have 3 times the level of access than we the people, their own constituents. Furthermore, when we look at who is actually giving to our incumbents and elected officials, we'll notice that the largest political influencers are almost exclusively wealthy white men, and men far outnumbering the number of women donors. In fact, millionaires who comprise just 3% of the U.S. population represent more than 45% of the congressional donors in any given year. Over 90% of the political donors are white, over 63% of them are men, and over 45% are white men, accounting for more than 57% of all political contributions. And to be clear, among the most elite political donors, there are virtually no large donors of color within that. Now, we all realize and recognize that the amount of money in our politics is deeply corrosive to our elected process, and is a corrosive problem that our nation has long struggled with. But we've also struggled with an even deeper problem, a profoundly undemocratic system where the vast majority of people lack basic access to participation and the political process. There still exists, even today, significant barriers to voting and political participation, where over 5 million people across the United States are either permanently barred from participating in elections by basically using their basic right of voting, or they're indefinitely restricted until they either serve decades in prison or pay off tens of thousands of dollars in fines, which most people in this country are not able to pay off. Furthermore, over 33 states still maintain some form of voter suppression laws, particularly voter IDs, which disproportionately target young people, elderly people, black and brown and Latinx people of color. Furthermore, beyond just those laws, there also exist a number of states where our congressional districts have been gerrymandered to intentionally dilute the voting power of particular communities, most particularly Black, brown, and Latinx communities of color. And if that weren't bad enough, there are also states that are engaging in ongoing efforts to purge voter rolls of more than 2 million voters, just for arbitrary reasons such as a lack of participation in the previous elections, or just trumped up registration errors such as entering in an address that was incorrect, or they couldn't read your handwriting. Even worse than just these basic barriers to voting and participation, there also has existed since the beginning of this country a lack of participation, a lack of representation in all levels of government, particularly amongst women, despite the fact that they comprise more than 52% of the U.S. population, as well as people of color who comprise 39% of the population, as well as young people, LGBTQ plus people, the queer and trans community, and poor people overall. In fact, despite despite the proportion of the population, more than 71% of all elected U.S. officials are men. 90% of them are white men, or are white, and 65% of them are white men. In Congress alone, the difference is even more stark, where 80% of congressional representatives are white men, and more than half of them are millionaires with a median income of more than $1 million. And if that weren't bad enough, we also exist within a two-party system where 2 major parties effectively have a duopoly that stifles all levels of political contribution, where there is absolutely no other political party that can effectively compete on the same level as just these 2 major parties. And they have existed for more than 150 years. True story. When we look at this system of how profoundly undemocratic we currently exist within the system, we have to really look back into the beginning of how this country was founded. And unfortunately, the objective reality remains is that our undemocratic system was rooted in injustice and inequality from the beginning, which has enabled this culture of corruption that we see today. The U.S. was actually, as many of us are realizing and know from our history classes and most recent history, we were founded upon an active, ongoing campaign of genocide, land theft, and slavery, built within a legal framework within the Constitution itself. The current power of wealth that many corporate owners currently enjoy was built upon an ongoing campaign of extraction and exploitation of the most vulnerable and marginalized communities among us. And we see this in multiple different ways across economic, social, political, and ecological grounds, where where majority of us are working with unlivable wages and that often pay us unequally based on our race and our gender. Automation that continues to take away valuable jobs that could actually provide for our families, shackling us with undischargeable debt such as our student loans, but also in other areas too, such as mass incarceration in for-profit prisons, an ongoing legacy from those days of one form of slavery that is effectively transformed into another. And we also see this too within the ongoing immigration crisis, where we're seeing mass deportations and a huge crackdown on all people who have migrated to this land, even whether they are unnaturalized or naturalized within the process. And of course, we're seeing that too within an endless campaign of war that we have effectively waged for more than 200 years of our country's history. Even worse than that, we're also seeing this affect the very planet that we live on, where climate change has become an imminent catastrophe, where we may not be able to survive through the next century, and this particularly is exacerbated among communities of color, where corporations have often located their most polluting and toxic factories based on one single category, based on a recent Princeton study, race. And from all this history and these current practices that we see today, we can tell objectively that low-income women and people of color, those households are typically the most impacted among us. But that doesn't mean that none of us are affected. All of us are affected by this current system. We see this here in California, most particularly just last year with the Paradise, California campfires that were caused by PG&E. We see this in the Midwest, in Michigan, where the Detroit water crisis, a man-made crisis where the city of Detroit effectively shut off access to local water supplies for unpaid bills to more than 300,000 people, which is still ongoing even today, despite the fact that they excused corporations who were contributing to the city who had unpaid water bills in the hundreds of thousands of dollars. And of course, we all remember Flint, Michigan, that was intentionally exposed to contaminated lead water that poisoned thousands of people, particularly young children, that will never recover from lead poisoning. It's a permanent defect. And many of these residents that still live in Flint are continuing to depend upon bottled water and can't depend on their local water supply to cook their food or bathe themselves. We've also seen this in the ongoing expansion of our fossil fuel infrastructure, where we are continuing to build pipelines, even through treaty protected lands of indigenous peoples in Standing Rock, North Dakota, and even under major water supplies, such as the lake that's built out in North Dakota, which the Dakota Access Pipeline will directly run through and potentially risk contaminating the water supply that is used by more than 10 million people. We also are seeing this too right now in the U.S.-Mexico border, where our own government is effectively closing our border and denying access to tens of thousands of asylum seekers and even legal migrants trying to just find a better life for themselves, fleeing violence in their countries that has been found to have been generated by our own foreign policy here in the United States. And this has actually led to a windfall where for-profit corporations who happen to own and run their own private detention centers are making a windfall off of the recent crackdown on immigration. And we're seeing this with thousands of people being crammed into prison-like conditions, children forcibly separated from their parents and families, and all unoppressed violence and conditions that basically are being described by even our own members of Congress as concentration camps. So from this pattern of great struggle and turmoil that we are experiencing here in just the United States alone, we can see how Citizens United and the problem of money in politics, as big of problems as they are merely symptoms of a much deeper problem within our currently undemocratic system, where there's an institutional advantage for wealthy donors and incumbents, and political access is determined by our race, gender, and class. So when we look at trying to address this fundamental problem of money in politics, we have to really recognize the ongoing legacy of systemic oppression and injustice that has existed long before Citizens United, and recognize that overturning just one Supreme Court case isn't enough to get to the root problem that was in Citizens United. And if we're going to really examine the problem, we have to look at where we began as a nation, where the Constitution was first ratified. The U.S. founders, in their wisdom, promised the people of this land a democracy where we the people are free and sovereign because we the people hold all the political power. But we delegate some of our power to government that is subordinate and accountable. Government discharges performs these duties by discharging and writing laws in the public interest, but no law can violate the private rights of individual citizens. Quick show of hands. Who here believes that we actually practice that here in this country? That's what I thought. The reality is, unfortunately, that when the Constitution was first written in 1789, it was written as a property rights document that focused exclusively on interest of property and commercial business, and added human rights, the first 10 amendments in the Bill of Rights, as an afterthought. When they did add, despite the fact that of a profound lack of human rights, there were only 10 amendments within the Bill of Rights, despite over 150 being proposed in the original debate over our Constitution. There was no definition of personhood anywhere within that language, meaning that the majority of people, unless you were white, male, a property owner, and over the age of 21, were actually considered worthy of protection under local, state, and federal law. So, and during this revolutionary period, this effectively excluded more than 90% of the U.S. population at the time of the founders' ratification of our Constitution. But most importantly, too, despite these profound flaws, there was absolutely no mention of corporations anywhere within the founding document, or the 27 amendments that have come after the fact. And the reason is because even during the Founders' Day, there was no question about the nature of corporations as they exist. Corporations are creatures of state law, established by English common law and enshrined in U.S. state law, literally since before the founding of the United States. Basically, what this is, the difference between a corporation and a human being is that corporations are legal entities created by state law where they're extended privileges to perform certain functions as a single entity. This includes the power to enter into contracts, to own property, to sue and be sued, and etc. But it was always understood that these legal rights came with certain responsibilities, which they had to execute in order to be incorporated. This was considered a privilege, not a right, because it was effectively extended limited liability for the shareholders, the owners, investors of that corporation, and they had to perform certain services to the public in order to be incorporated. That's profoundly different from human rights, where we did not gain our rights from ratifying the Constitution, but we have always retained them as living, breathing human beings. And we enshrined our rights within the Constitution, not merely to give ourselves power, but more as a statement of principle, where we made clear that government was constrained to exercising its duties without violating these sacred and inalienable rights that we hold dear and retain amongst ourselves. So constitutional rights as they exist are a restraint on the use of government powers that we have delegated to them. Now, This framework actually worked quite well, both for, particularly for corporations, well into the 1880s and 90s. Corporate charters in the past were required to be approved by the state legislature. Basically, they had to create a law that had to be signed by the governor, and this would effectively create a corporate charter, incorporating the organization to perform a certain purpose that had to be defined and with an express benefit to the public. And it was often limited in duration, where usually after no more than 50 years, they would have to go through the legislative process again in order to continue to operate as a corporation. But most importantly, they were prohibited from participating within the political process, even being enshrined within other state constitutions, such as the Pennsylvania Constitution, which had a specific section within it that allowed the state legislature to alter, revoke, or annul any corporate charter if it were to violate their laws of their land, or harm their sovereign citizens. This has changed drastically since the 19th century. Corporations today don't need to go through the legislative process or be approved by any elected governor. They basically just have to write an application to a state law clerk, pay a small fee, typically about $250, and they are incorporated for an indefinite duration. They can basically exist forever, which is why we have corporations like J.P. Morgan Chase and Standard Oil that eventually became what we know as Chevron today, that have effectively existed for more than 100 years. If that weren't bad enough, they also do not have to define what purpose that they serve. And it has no purpose except for one: to maximize the wealth of their shareholders and the profit of their companies, as decreed by the Michigan State Supreme Court in Dodge versus Ford of 1919. This effectively allows corporations to externalize the costs of doing business onto the communities that they serve, most particularly the most vulnerable and marginalized communities with the least amount of political access and power to themselves. Furthermore, there is no limit on their political participation, which is why we see corporations that continue to spend unlimited amounts of money, such as Koch Industries and and their owners, the Koch brothers, giving hundreds of millions of dollars to the candidates of their choice. How did we get here? Basically through a series of Supreme Court decisions that have extended inalienable constitutional rights under the First, Fourth, Fifth, and 14th Amendments. This even includes the original drafting of the Constitution, where even they have certain rights under the Commerce and Contracts Clause. And they use these effectively to overturn locally enacted regulations and influence our legislators, including writing model legislation and buying political ads to influence voters' opinions. But this wouldn't have been possible if not for the founders' framing of the Constitution, which focused explicitly our priority on protecting and maintaining property rights of a certain few individuals over the human rights and well-being of the many. So prior to the 14th Amendment, prior to 1886, was expressly intended to protect the civil liberties and freedom of African Americans following the abolition of slavery under the 13th Amendment. And this was even affirmed as recently as 1877, where the Supreme Court did find that the corporation was not a person protected under the 14th Amendment from state law. However, less than 10 years later, a certain decision built right here in Santa Clara County. Anybody familiar with Santa Clara County versus Southern Pacific Railroad? Yep. Basically, this was a Supreme Court case where the Chief Justice at the time, Morrison Waite, opened oral arguments to make clear and state this quote right here, where the court does not wish to hear argument on the question of whether the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of its laws, applies to corporations. We are all of the opinion that it does. Now, mind you, the case itself didn't have anything to do with 14th Amendment protections for corporations. However, thanks to a rogue Supreme Court clerk by the name of Bancroft Davis, a man who just so happened to own his own railroad company simultaneously while serving as a court clerk, included this within the headnote of the official court opinion. And sure enough, just 2 years later, the court would recognize this headnote, not supposed to be official court opinion, but still incorporated it within the official court opinion just 2 years later in a Supreme Court decision known as Minneapolis and St. Louis Railways versus Beckwith in 1889. And from this decision, we have seen a disastrous effect within all levels of both social, political, and economic, where corporations are now effectively able to use their rights or are able to claim 14th Amendment rights to open chain stores, build massive amounts of wealth and capital through our local economies without ever having to really contribute their fair share within it. They're able to construct cell phone towers and enact other dangerous practices against the will of our communities, and they're able to resist democratic efforts to prevent corporate mergers and revoke corporate charters through citizen-led initiatives, such as AT&T and Time Warner's merger, which has effectively created one of the largest telecommunications companies on earth. But at the same time as the court was expanding personhood for rights for corporations under the 14th Amendment, it was effectively restricting human rights during the same time period. For example, in 1874, when women first cited the 14th Amendment and tried to claim equal protection so that they could have an equal right to vote, the Supreme Court rejected their argument, stating that the 14th Amendment, that the women's right to vote is not guaranteed by the Equal Protection Clause of the 14th Amendment. And effectively, it was left up to the states to decide whether women had the right to vote. In fact, the court would not apply equal protection to women until as late as the 1970s. In the 1971 case, Reed versus Reed, nearly 100 years after corporations were recognized as persons under the 14th Amendment. And in fact, in the 30 years after the Santa Clara County ruling, the Supreme Court would apply the 14th Amendment to corporations more than 300 times, compared with less than 25 times to African Americans. And this is the same time period where we saw the proliferation of the black codes, also known as Jim Crow laws, emerging across the South to put black people back in chains, while the court would actually deny equal protections for black Americans for more than 55 years under its controversial separate but equal doctrine established in Plessy versus Ferguson. And during the first quarter of the 20th century, the court would continue using the 14th Amendment rights to overturn more than 200 democratically enacted regulations established in local and state law, effectively making it so that corporations could thwart local and state governance during the court's corporate-friendly Lochner era. That wasn't the only constitutional right that they were able to claim. Thanks to the Supreme Court opening the door under the 14th Amendment, they were also able to claim certain Fourth Amendment rights, to claim immunity against searches and seizures for their books, records, and property. And it came in a famous dissent where Justice Harlan forewarned that denying that the decision was basis for preventing the corporation from investigating the books of corporations. Government couldn't open a corporation's books and risk violating their rights under the Fourth Amendment. In fact, Justice Harlan stated in this opinion right here, he went further beyond this to say that if contrary view obtains the power of government by its representatives to look into the books, records, and papers of a corporation of its own creation to ascertain whether that corporation has obeyed or has defined the law, will be greatly curtailed or if not outright destroyed. And we see the impact of this on a daily basis, where their Fourth Amendment rights effectively allow corporations to avoid subpoenas for unlawful trade and price fixing. It allows them to prevent citizens, communities, and regulatory agencies from stopping corporate pollution, such as ongoing efforts to prohibit local bans on fracking and other fossil fuel practices that have harmed local communities. And it also prevents our own regulatory agencies from investigating health and labor violations and other assaults on people of the commons without a court-granted warrant. And we've seen this in recent examples such as the Deepwater Horizon oil spill in 2010 that contaminated and most likely destroyed much of wildlife, marine life in the Gulf of Mexico. As well, and we've seen it most recently too in the Boeing 737 MAX airplane disasters, simultaneously back to back, despite multiple reported safety problems with the aircraft before it was instituted. And while corporations were having this renaissance and extensive protection for their privacy, the Supreme Court and other institutions of government were violating our own protections for basic human beings. Once upon a time, police officers in the United States were limited to conducting searches or seizures of property and people only when they had probable cause to reasonably believe that a person had committed a crime or is in the process of committing a crime. Unfortunately, thanks to a Supreme Court decision in Terry versus Ohio and Wren versus the United States, the Supreme Court expanded police powers to basically search or seize, also known as stop and frisk, anyone on basically their reasonable suspicion, which is so vague that it allows them to effectively racially profile Americans of color, particularly black Americans, from doing basic human activities like yourselves, such as going to the store, walking their dogs, or caring for their lawns, even just on the reasonable suspicion that they might be violating traffic laws as well. Furthermore, U.S. regulatory agencies continue to allow corporations, private entities created by state law, to violate the basic privacy rights of its consumers. We all are familiar with the Cambridge Analytica scandal that happened recently, where Facebook was found to be selling private information of millions of its users. And what was the government response to that scandal? $5 billion fine. The highest in its history, but during a quarter profit where Facebook made more than $15 billion. It means absolutely nothing to a multi-billion-dollar company making this much money. Furthermore, Amazon, Google, and Apple have most recently been discovered in the last couple months that they have been actively listening to people through smart devices like Alexa, like Google Voice, and even Apple's iPhone Siri program. And no action has been taken against by government or regulatory agencies yet on this. Beyond just the Fourth Amendment and 14th Amendment protections, it also opened the door for corporations to claim Fifth Amendment protections, most notably under its takings clause, where the Supreme Court effectively found that regulations by government, whether they're environmental, health, or labor protections, are effectively a form of takings by the government. And because the government cannot take property without just compensation, corporations are effectively entitled to just compensation for their lost profits. And this played out as far back as 1922, where the Pennsylvania Coal Company it was mining for coal under residential properties within Pennsylvania, where they were creating these massive sinkholes, destroying local properties and homes, as well as contaminating local water supplies. And when the Pennsylvania legislature effectively outlawed the process with one of the first environmental regulations of its time, the Pennsylvania Coal Company sued all the way to the Supreme Court, where it effectively found that the Pennsylvania law was a takings by the government, and that Pennsylvania state was required to pay just compensation to Pennsylvania Coal Company for not being able to mine under residential properties. This continues well into today, and we see the disastrous effects. This is a sinkhole opened under an abandoned coal mine in Des Moines, Iowa. There is a coal ash pond spill where millions of gallons of toxic wastewater filled with the coal mining product spilled into a local Tennessee community. And we see that too happening within natural disasters, where places like Houston, Texas, after Hurricane Harvey, where entire communities were flooded next to chemical plants that were that had basically caught fire because local corporate crews that were managing the facilities couldn't manage it during the massive flooding and the immediate after effects of the storm. Beyond just these effects against communities and our environment, the Fifth Amendment has been used by has been used and cited by the Supreme Court to give money to corporations while taking away from human beings explicitly. In particular, the Fifth Amendment power of government for eminent domain, that power of takings by the government that are required for just compensation. Well, the same Supreme Court found that government can force people to give up their homes, their farmlands, and other properties to large corporations for the express purpose of generating economic development, or also known as private profit. Most notably within the city of New London in 2005, where the government took property from one property owner to give it to a private corporation for the express purpose of generating economic benefit that was supposedly to go to the community itself. Unfortunately, once this decision was found, that same corporation that New London gave that property to ended up not following through with its contract, which basically squandered whatever economic benefit or development would have gone to the city, had it with that power. But they can still claim it in other areas. They've also used the Fifth Amendment to create this practice of what is known as civil asset forfeitures, where government, police in particular, are able to seize property under the Due Process Clause without charging a person with the crime. It effectively means that government can charge crimes to property and can basically charge property with a crime and then claim and then seize property in that fact without charging the owner of that property. And this is legally justified as a revenue source for local police departments across the country, and including federal agencies like the FBI and the DEA. And this is worth billions of dollars across the board. So, fast forward to the Fifth Amendment takings clause. I realize I only have a couple minutes left in this speech, so I'm going to speed things up a little bit. But the First Amendment, before 2010, the Citizens United decision, the Supreme Court was slowly but surely whittling away to give corporations the opportunity to claim free speech rights. First and foremost in Buckley versus Vallejo of 1976, which was the first Supreme Court decision that found the act of spending money to influence politics or a campaign was considered protected speech. So effectively ruling that money is a form of protected political speech under the First Amendment's free speech rights. They would continue to expand this to include corporate spending for influencing or affecting voters' opinions in First National Bank of Boston versus Bellotti in 1978. And then it would even go to extend First Amendment negative free speech rights, basically the right not to speak to a corporation in International Dairy Foods Association versus Amistoy, where it effectively denied the power of state governments like Vermont to require dairy producers to disclose whether they were providing dairy products that were laced with that were coming from cows using a banned human growth hormone, bovine growth hormone. But none of these court cases effectively extended the First Amendment free speech rights until 2010, where Citizens United finally broke down the final barrier and recognized that corporations are people and cannot suppress their political speech based on their corporate identity. And this effectively means that for-profit corporations, non-profit corporations, and even unions are able to spend unlimited amounts of money in independent political advocacy to influence voters' opinions, so long as they're not coordinating directly with a campaign or a political party. They continued to whittle this away under the Roberts Court in 2014, where they not only established that the government has no interest or has no governmental interest in stopping corruption beyond the basic quid pro quo corruption, where I'm specifically paying a government official for a specific favor. It also tore down the aggregate limits on individual donations, meaning that on top of a corporation's independent political advocacy they spend in elections, they can also, their owners can spend as much as $2 million directly to a candidate or a political party. And it didn't stop at just the First Amendment free speech rights. It also went to their religious rights in 2014, Hobby Lobby versus Burwell, where it found that certain corporations, those owned by a closely owned family, are exempt from laws that its owners religiously object to, effectively allowing Hobby Lobby to deny contraceptive services and other health coverage to their female employees based on their Hobby Lobby's owners' religious objections to the Affordable Care Act. So with these, we've already seen the effects of how this expansion of First Amendment free speech rights to corporations has effectively allowed them to advocate for everything that we could possibly hate, despite going completely against the will of our communities, and no matter what kind of harm it does. And they can even deny basic coverages and services based on their owners' religious objections on top of that. So we see from this history how corporations, we already know their nature, where they do not get sick, they don't go to jail, they're not human beings. They don't depend upon any of the basic needs or necessities that we, the people, human beings, actually depend upon. Yet they will use their money to oppose basic social protection services, social services like health care, education, environmental regulations, labor protections, food regulations, and all sorts of other social goods, unless, of course, they can make money off of those protections. And they do so. So while human beings had to struggle, fight, and die for their recognition as persons through mass social movements, corporations have been able to effectively spend their money on lawyers to convince unelectable judges on the Supreme Court to extend to them the same constitutional rights that we have fought and died for over more than 2 centuries. And as long as a corporation is considered a person with the same inalienable rights as human beings, and their money is a form of protected political speech, they can afford to assert their rights, their interests, better than any human being or our community through their sheer concentration of wealth. And when corporations are effectively free to legally claim the constitutional rights of human beings, the law cannot be equally applied. So if we're actually going to hold corporations accountable and recognize them as the public entities that were expressly created to benefit we the people and serve the common good, we have to change the fundamental law of the land, being the Constitution. Which is why we have proposed an amendment that's been introduced in 4 Congresses now called the We the People Amendment, House Joint Resolution 48, that would make clear constitutional rights belong to human beings, natural persons only, and that artificial entities such as corporations and other limited liability companies have no rights under the Constitution and are subject to regulation by the people through local, state, and federal law. It further stipulates that money is not a form of protected political speech, and that government, at all levels, has an express duty to regulate, limit, or otherwise prohibit contributions and expenditure for the express purpose of guaranteeing that all people, regardless of how much money they have equal access to the political process. And whatever contributions are permitted, it makes clear that these must be publicly disclosed so we know where the money is coming from. So what can we do? Spread the word about corporate constitutional rights alongside the money and politics argument, and start conversations about how corporate rule directly impacts our daily lives. Also build public support for the We the People Amendment here in Silicon Valley and beyond. House Joint Resolution 48 already has 63 co-sponsors in the House, and our goal for the end of the year is to get 75 co-sponsors and to get it introduced in the Senate for the first time, which we just had awesome development over the weekend where one of the leading presidential candidates, Bernie Sanders, publicly sponsored, pledged to sponsor the We the People Amendment in the Senate. So we can, now is the time to take action, and with that, I will open up the door for questions about this.
Well, you know, all the current amendments have all these loopholes in it. Mm-hmm. How in the hell can you get around them? What is your amendment?
Perfect question. Then, in fact, we get that a lot because the primary concern when we go take this to members of Congress is the unintended consequences of abolishing the court's expansion of corporate personhood to include constitutional rights. And we've been very intentional about drafting this language so that we don't actually take away all legal personhood for corporations. As I said, the legal rights of corporations are established by state law, not the Constitution itself. And this amendment does nothing to alter that framework. In fact, this reaffirms that framework by stating publicly that corporations have no rights under this Constitution or are subject to regulation by the people through local, state, and federal law. So that means that while they will not have the constitutional rights under the 1st, 4th, 5th, and 14th Amendments, they will still maintain their power to enter into contracts, sue and be sued, and own property under the basic framework that's established by state law. There's a difference between statutory rights and constitutional rights, which the U.S. founders had never extended to corporations in the first place and were only granted to corporations through the Supreme Court, unelectable judges that are appointed, not elected.
I really enjoyed your point. I just wanted to ask a question. Has anybody seen the movie One Child Nation? It's about China when they enforced one child and the horrible things they did to people and to newborn babies. And it just shows power is very corruptible. And these corporations are very powerful, and we have to fight against them.
Mm-hmm. Thank you. Understandable.
How do you distinguish the type of corporation? Like the Humanists are a corporation of a sort, and the ACL is a corporation. How do you draw that line?
Another good question. So when we're talking about corporations, we're talking about entities that are incorporated by state law. And that includes nonprofits and unions. Nonprofits like Move to Amend. And this amendment won't actually affect the power of nonprofit organizations because, according to the Supreme Court, nonprofit organizations like the Humanist community of Silicon Valley already have standing to speak on behalf of the rights of its members. This was established in Supreme Court cases like NAACP versus Button and NAACP versus Alabama, where the Supreme Court recognized the NAACP's power as a nonprofit to speak on behalf of the rights of its individual members. You all, as individual humanists, do not lose your constitutional rights, and your organization, the Humanist community of Silicon Valley, is merely as a representative of your membership, speaking on behalf of the rights of its members. And with that framework too, the Supreme Court has never found that nonprofits are the same as for-profit corporations either. And this is most particularly notable with unions, where unions have under Citizens United do have free speech rights the same as corporations, but they're actually not considered the same as for-profit entities, which is why they are subject to even greater scrutiny than for-profit corporations under the National Labor Relations Act. That's why they're required to publicly disclose their finances better, more so than for-profit corporations are, and unions themselves can't compete with a corporation's for-profit coffers when they themselves, by their nature, are a non-profit entity dependent upon the contributions of its membership. And the Supreme Court continues to whittle away at the power of its membership in recent decisions like Janus versus AFSCME that basically gutted fair representation and fair dues protections and such. So this amendment will actually stands to level the playing field by making by further clarifying that all artificial entities are subject to regulation by the people, just the way that nonprofits like unions are, and nonprofits like ourselves, and it would make it easier for those nonprofit organizations and unions to make serious headway on the systemic issues that they're seeking to address, without having to compete with a for-profit treasury such as corporations are.
Question on terminology. In your slides and your talk, you talked about unelectable judges. I understand these judges, like the Supreme Court judges, are unelected, but they're unelectable. Doesn't make any sense to me.
Gotcha. Like in terms of like them being unelectable, meaning that it's like they're lifetime appointments. Yeah, they're lifetime appointments, and they are not subject to any kind of oversight by the people. They're basically only subject to the people who are elected to public office, and that comes from a very small proportion of the population. For instance, in 2016, less than 40% of the total eligible population that was of U.S. voters actually participated in the presidential election process. And Donald Trump was elected with less than 20% of the vote. So that's the very definition of minority rule, and by and large, too, that extends to those unelectable judges that Donald Trump appointed, like Brett Kavanaugh and Neil Gorsuch.
As I understand it, the corporations were invented at the formation of our country. Mm-hmm. And the rule was that if they didn't obey certain rules, the government could shut them down. Is that true?
Yeah, absolutely. That was how it was.
Well, why hasn't it happened?
Right, I mean, they weren't invented by the U.S., no. They were established, there's a long history, actually, of corporations that dates back all the way to ancient Rome, but they were specifically established in the United States under English common law, where the charters were given authority by the king, and that extended into U.S. state law from the founding and so on. But you're absolutely right. They used to be enforceable, and their corporate charters could be revoked until they were recognized as equal persons under the 14th Amendment's Equal Protection Clause by the Supreme Court, and that effectively screwed up the entire framework. So now, those private institutions created by our government, which government it derives its power from the people that we delegate to it, effectively means that those institutions now are considered private citizens the same as you and me.
I don't see how this will work then.
Mm-hmm.
Hi, I'm Dick Hewitson. I'm very concerned about what you referred to as a duopoly of two parties in this country, which has been driving me crazy for a long time. Mm-hmm. How does what we're talking about address that?
Well, good question. Again, if we are able to pass the We the People amendment, it would effectively make it clear that private corporations, which the Democratic National Committee and the Republican National Committee both are private corporations in and of themselves, are subject to regulation by the people. And the reason that we have this two-party duopoly is because these two major parties have effectively created laws that have raised massive barriers for other political parties, as well as independent candidates from equally participating within the political process, i.e. running for election, where nowadays, in order to qualify for public financing, which both major parties easily qualify by winning more than 10% of the vote, parties like the Green Party, the Peace and Freedom Party, and all other forms of third parties are effectively barred from access because they can't clear the threshold to qualify for public financing. And it makes it even hard, it makes it even more hard for candidates that to run outside of the political party when, say, the primary process is completely controlled by the DNC or the RNC, such as when Hillary Clinton was was clearly favored by the DNC, and the DNC actively worked in support of their chosen candidate against the will of Bernie, such as Bernie Sanders, who had the popular vote among their base.
Trump has recently stated that he wants all corporations to stop trading with China. Does he have the power to do that, to control all the corporations?
Short answer, no, he cannot. He's basically saying that private citizens are not allowed to participate in foreign economies, but more importantly than that, the president doesn't have such power. So that's completely outside of this, really. But it's quite funny that he would think that he has that power.
He wants that power.
Mm-hmm.
I think that corporate media is a major beneficiary of corporate spending on political matters. So can we expect a biased campaign against this from our sources of news and opinion?
Good question, actually. And the short answer is that we already have, actually. A Move to Amend has been launched literally the day that the Citizens United decision came down, January 21st, 2010. Yet a lot of and despite the fact that a majority of the public, more than 80%, polled as recently as 2017, were found to agree with us that corporations should not have the same rights as people and that money should be regulated in our process, most of the public doesn't even know that we exist or that there is a movement for a 28th Amendment to address both of these court-created doctrines. And that's because corporate media has been consolidating itself for the past 2 decades. For-profit corporations now control 90% of what we read, watch, and listen to. That power is held among 6, going on 5 mega media corporations. And this amendment, if it were to pass, would effectively potentially affect their bottom line. So of course they're going to be against it. However, that's why we have to be our own media sources, which is why we continue to be picked up by progressive outlets and nonprofit media institutions like The Guardian, not like HuffPost, but Common Dreams and Truth Out, all sorts of other publications and such, and in these times as well.
Now, this would have to be passed by Congress, correct?
Correct.
What are the chances of that with the Republicans then? You're whistling Dixie.
Good question. So to address that point about Republicans, this is actually one of the few issues that transcends the political partisan divide. In fact, we've managed to help pass more than 800 local ordinances and resolutions across the country in liberal and conservative communities alike. This includes conservative communities like Waukesha, Wisconsin, former Republican Governor Scott Walker's hometown, where in the same year it re-elected him during his recall election, approved one of our ballot initiatives by more than 70%. And we've managed to pass these ballot initiatives more than 350 times, usually in landslides of more than 60 and 70%. And that includes 20 state resolutions, including in red states like Montana, where in 2012 approved one of our state resolutions along our language by a margin of 75 to 25%. And our amendment proposal was the first amendment on this issue that received a Republican co-sponsor, the late Walter Jones of North Carolina. And we moved to amend in 2016, the same year that Trump was elected, earned its first Republican Party endorsement in the Pottawatomie County Republican Party of Iowa. So this is one of those few issues that definitely transcends the political partisan divide, because at the end of the day, corporate constitutional rights, if there's one thing that we can agree on, whether we're liberal, whether Republicans, Democrats, Libertarians, or Greens, or Independents, is that corporate constitutional rights, them having the same rights as human beings, directly infringes and thwarts our own sacred right of local sovereignty, our right to self-government.
Thank you for this description, this talk, and this effort. There are others that want to go even further and have a constitutional convention to rewrite the Constitution, bring it up to date with situation today, including, in particular, the Second Amendment. Do you have a position on that? Does Move to Amend take a position on a constitutional convention and rewriting the Second Amendment?
We do. While Move to Amend is focused right now on getting the amendment passed through Congress, because that is, has how the last 27 amendments have been passed and is therefore the most successful method. We haven't taken an amendment proposing convention under Article 5 off the table, specifically because of its history. There have been as many as 5 attempts to call for a constitutional convention or amendment proposing convention since the first constitutional convention, most notably with the 17th Amendment's direct election of senators, where 26 states came very close at the time to calling for the first constitutional convention since then. And when Congress saw that this was very likely to happen, they took action and passed the 17th Amendment to allow the direct election of senators. So we know from this history that Congress doesn't like to cede power to anyone, much less the states. So if we have that, so that effectively means that Article 5's amendment proposing convention is an effective tool for leverage. And our campaign is not working just from the top to bottom. We're building power from the ground up, which is why we're working to pass local resolutions in support of this amendment. That's why we're working on passing state resolutions in support of this amendment. And that's also why we're asking candidates at all levels, local, state, and federal, where they stand on this amendment. Because whether they go to the Congress or they go to the state legislature, we need to be ready to have people in place for when the amendment comes up to a vote in the state legislatures, that we can hold their feet to the fire and and remind them that they supported this amendment as they climb the top of the political office. And we're working a multifaceted campaign where we can be ready, if Congress doesn't take action after a certain amount of time, to propose for the states to take action and take themselves and propose this amendment. Most notably with certain state legislation, model legislations like the We the People Act. Right now there's a version of this going in the Massachusetts state legislature, which would basically put the state legislature on notice, passing binding legislation, calling on Congress to propose this amendment and vote it out to send it to the states for ratification. But if Congress doesn't take action after a certain amount of time, then their legislation would automatically convert to an Article 5 petition, calling for a state convention specifically on this issue. And to address the concern where it comes to, the potential of a runaway convention, it's really important to be clear. Whether we go through Congress or whether we go through the state legislatures through this Article 5 convention, anything that comes out still has to be ratified by 38 state legislatures, 3/4 of states. So, and we can effectively thwart, this potential of exploding into a bunch of different amendments by being clear within the legislation what amendment language we specifically want to focus on, which is what the We the People Act in Massachusetts and in other states that are being proposed, like Minnesota, are effectively working to do. So we're definitely keeping it on attention, but regardless of what route we go through, right now we're focused on Congress. We have to build the mass movement powerful enough to force Congress and the states to take action on this. So that's what we're focused on.
Have you gotten any response from any of the contenders for the presidency?
Ask questions from the audience.
Oh, sorry. Yes, we actually have. Bernie Sanders just this Friday.
Repeat the question.
He asked if any of the current presidential candidates have responded on this issue, and the answer is yes. Bernie Sanders in Paradise, California, was publicly asked by a Chico resident to whether if he would sponsor the We the People Amendment in the Senate, and he said without hesitation, the answer is yes. And that's on video if you go to our website.
And none of the others have responded?
So Move to Amend.
I can answer your question.
Move to Amend has been active now for quite a few years. Do you have a timeline on when you see this happening?
Yes, we do. In fact, in 2016, we came out with our 10-year strategic plan to pass the We the People Amendment. Basically, our goal to pass this amendment is we seek to pass it through Congress by 2025 and then ratify it through the state legislatures within the 2 years afterwards. And what we've done to work towards this goal is set ourselves clear benchmarks that we have to meet each year in order to be powerful enough to pass the amendment through Congress and ratify it through the states. So our goal for the first year was to get 45 co-sponsors in the House of Representatives when we put this through. We actually ended the year with over 50 co-sponsors, clearing the goal. And then last year, our goal was supposed to be just 50 co-sponsors. We raised it to 60, and we managed to clear it with over 65 co-sponsors. And this year, our goal for the House of Representatives is to pass it with 75 co-sponsors. As of today, we have 63, with at least another 2 that are going to be signed on within the next 2 weeks. And so that's why right now we're particularly focused in on getting this amendment introduced in the Senate for the first time. That's the goal that we really need to meet with at least 5 co-sponsors. And so far, we've managed to post this through to, we've managed to get commitments from at least 5 senators' offices. But we need to get that lead sponsor, that champion in the Senate, to actually introduce the amendment.